The question that comes up very frequently is, what is the difference between arbitration and mediation? If you have a dispute with somebody, whether it's a court case or a contract case, many times the subject of mediation or arbitration will come up, and it's important to know the differences between the two. First of all, both methods are an alternative method of resolving a dispute, what's called ADR, Alternative Dispute Resolution. And it's an alternative to the legal process where you go to court, you have a lawsuit, or you have other legal proceedings. And the alternative methods, such as mediation and arbitration, have advantages because you're not going to have legal fees, you're not going to have the whole court process, which can take months or even years in some cases. And you also have some control over the process. With the court process, you're basically surrendering your outcome to the whims of the court. It could be a judge, could be a jury. With arbitration and mediation, you retain some control over the process. In fact, both of them are considered to be plaintiff-controlled processes. Now, here's where the differences come in. Mediation is a form of having a third party to assist with a voluntary solution. It's an alternative process for conflict resolution, and it provides advantages over going to court. The parties can do it with or without an attorney, have a third party mediator to help facilitate a conversation between them and to help both sides discuss and clarify their interests and what their concerns are. Many times the interests and the solutions already have a lot of overlap. They don't need as much dispute resolution as needed. The parties retain control over that process, including the format, the when, the where, the how, who can attend, how to resolve the dispute. It's a lot less expensive than going to court. And it can occur any time during the conflict or dispute. Mediation is confidential, and it's a less threatening environment than going to court. The solutions can be more creative, where courts may have certain requirements of they can only do certain things. And you can custom tailor the solution to both parties or all the parties, where the court might not be able to do that. In mediation, the mediator doesn't tell you what you have to do. It's usually not binding. It's a suggestion, and they try to facilitate the result so both parties voluntarily agree to what the mediator suggests or comes up with. Or in many cases, they don't suggest or come up with anything. They show the parties where they already have an answer. Now, once the agreement that the mediation process produces is signed, now that's binding. So both parties still have control over their future during the mediation process. Now, if the mediation doesn't produce a desirable result for both parties, no harm, no foul. You start back where you were. You can look at another form of alternative dispute resolution like arbitration, which we'll talk about now, or you can go to court. Now, arbitration has some similarities. It's a third party that's neutral. The third party isn't related to either one of the conflicted entities. They're not taking sides. And the arbitrator takes information from both parties and looks at what the solution might be. Now, the difference is, unlike mediation, an arbitrator serves as kind of like a private sector judge, and they listen to the evidence and they make a ruling to determine the outcome of that conflict. The other difference is the arbitrator is in control of the process. They dictate when, where, and how things are going to be done, and they're usually more flexible than courts. You don't have to have a hearing date or discovery dates. They usually give you more flexibility than a private or public sector court will. But it is less formal than a court case. However, the difference is the arbitrator's ruling is final and usually binding on both sides. You may be able to appeal it. You may be able to go to court. Usually that's limited by contract or by what's dictated by the court. But that's the difference. One is not binding on the parties. A mediation is voluntary. The other is who's in control of the process. Usually in mediation, the parties are in control with the mediator facilitating it, suggesting dates, times, and whatnot. Where in arbitration, the arbitrator says, here's how we're going to do it, and here's what the process is. So hopefully that clears up what the differences are. They're both very valuable. Anything you can do to keep out of court is a good thing. Ask any lawyer. They'll tell you, stay out of court. As soon as you go into court, the whole thing's out of your hands. You don't have control over your destiny anymore. So anything you can do to stay out of court is good. Mediation, arbitration, negotiation, whatever it is a good thing. A neutral third party helps because it takes the feelings and thoughts and maybe baggage out of the equation, where if you are negotiating directly or even with your attorneys, you're going to have some baggage involved. So a neutral third party can help quite a bit in either case.